That's why we see decisions sometimes come out that don't make sense in immigration space because they don't grasp the whole law because it's just such a nuanced side area of the law that people don't deal with.
It's a challenge, and a lot of times it's a challenge because you don't have a hearing, right? So it's just written paperwork. So, for example, we litigated one L1A case where they denied the petition, but they put the gentleman was here, so he was doing a change of status from B to L. So they put the person in proceedings, and the district court incorrectly said you haven't exhausted administrative remedies because there's a removal proceeding. And we try to explain to the court that, wait a second, the L cannot be reviewed by the immigration judge. The judge is reviewing the beneficiary status or whether he has status or not, but not the petition, the L petition. She cannot review it and say, yeah, the L should have been it's improperly denied. But she denied it, saying, oh, you need to exhaust administrative remedies, go through the removal process before you go to the district court. So we appealed that to the 11th Circuit Court of Appeals. It took like 3 years.
Wow.
But eventually we won an appeal at the 11th Circuit Court on a dissent that correctly said, oh, wait a second, different parties, beneficiary versus petitioner, different forums, removal proceedings versus a district court. Everything's different here. And the district court judge just, made it up.
Even if they're approved, then I mean, the business is probably like not continuing, or the job is not there. It's like really like disruptive for that kind of delay.
Totally, and sometimes, now Chevron, everybody's praising. Oh, Chevron's gone. It's all great. I hope so.
Yeah,
I remain hopefully optimistic, but conservatively. I mean, because some courts are not friendly. They're not friendly to some of these petitions. I mean. And like you said, in some of these decisions, deference or not, what happened to us in Patel, for example, that was all statutory. And the 11th Circuit Court of Appeals reversed itself, and both parties were arguing for jurisdiction. I don't know if I guess your listeners know what Patel is, but it was a big decision where the court itself ruled it on the statute, right? That there's no federal court review to check on I-485 denial, except in removal proceedings. And even if some federal court review survives, it's in very limited circumstances.